Hi everyone, thank you for joining our webinar today on AI and legal risk for insurers. Just a bit of housekeeping at the start. If you have any questions for us during the talk, you can pop them in the Q&A box at the bottom of your screen, and we'll leave some time at the end to deal with those questions. Might move on to the next slide. By way of introduction, my name is Laura Prendiville and I'm a Senior Associate on the Insurance and Risk team at Mason Hayes & Curran. I'm delighted to be joined by my colleagues Brian McElligott and Laura Herangi. Brian is a partner here at MHC on our technology law team, and he is the head of artificial intelligence. Brian has significant experience in AI platforms and solutions. He helps clients prepare for compliance with the AI Act, deals with complex technology and IP issues, and is an expert in implementing business-focused AI strategies. Laura is a partner in our dispute resolutions team, and she's also the head of our data solutions group. As part of Laura's role, she advises our clients extensively in the use of AI, both in civil disputes and in criminal investigations, as well as in the context of data access requests. We might move to the next slide, please. As we all know by now, AI is set to transform the legal landscape over the coming years, both in litigation and in claims management generally. I came across a recent study that said that 80% of insurers are exploring deploying AI solutions, and 75% of insurtech companies have also implemented AI into their live products. We know that across the insurance industry, AI is currently being applied in underwriting, pricing, and customer service by improving efficiency and personalizing products. It's also being used very helpfully in fraud detection, claims processing, and claims management. The regulators are also starting to scrutinize the use of AI in the insurance industry. At the end of September, we saw the central bank said that they will be focusing on understanding the use of AI systems in the insurance sector. They said that this will involve assessing whether firms have the necessary governance and risk management measures in place to leverage AI responsibly. So we will have a look at how to implement AI responsibly today. I've listed a few case examples here on this slide where AI has cropped up before the courts, both in Ireland and further afield. Laura is going to discuss some of these cases in more detail later on, but what we are seeing in these cases and what is illustrated is that some lay litigants are using AI-generated legal research for submissions in court. So what tends to happen if you're using an AI platform and it doesn't receive the correct instructions on what to look for, it can hallucinate. In basic terms, that means that it can come up with non-existent or phantom citations as part of the output, which is obviously a huge issue for legal documentation. We have seen cases being struck out for an abusive process due to the use of AI, solicitors being referred to the regulators, fines against solicitors, and courts warning litigants against the reliance of AI-generated material. The courts have said it can sound convincing, but it's not always correct. There's a significant risk to litigants in relying solely on AI tools, and these cases that Laura will speak about demonstrate the importance of proper human oversight to ensure accuracy. The purpose of this session is not only to discuss how to mitigate risk when using AI within an organization, and I suppose what can go wrong, but it's also to provide actionable guidance on implementing AI-driven solutions within your organizations. Using AI within a business needs to start with a basic understanding of the regulations. So I'm going to hand you over to Brian now to discuss the AI Act and AI governance.
Thanks very much, Laura, and thank you everybody for giving us your time today. So what I'm going to do over the course of the next, say, 25 minutes, half an hour, is to have a look at two particular aspects of onboarding and using AI, which is the hard legal piece, which is the AI Act, and then also the kind of softer but also equally important concept of AI governance. And in the space of this time, we're not going to get into any sort of level of detail, but what I'd hope to give you is some sort of a way of thinking about the technology that might allow you to implement it in a ordered and safe manner, and make sure that you are at least hitting the big picture risks. So if we could move on to the next slide there, please. We're going to start with the AI Act, and this is a little bit of a busy slide, but it's my effort at trying to explain the AI Act in one go in a visual manner. And hopefully what I'm going to be able to do for most of you is narrow it down to a couple of these little images for you to focus on. So the AI Act, the first thing to know about it is that it's EU product safety law. It is not the GDPR, which is generally acknowledged a kind of a fundamental principles and fundamental rights type law. It's hardcore, old school EU product safety law. And what do I mean by that? I mean that it treats the technology as if it's a product. It says certain uses of the product come with risk, and then it regulates those uses. It doesn't regulate the technology itself. Having said that, there is an element of kind of fundamental rights aspects to it, but we don't need to go into that level of detail. Big picture, when you're looking at this slide, you'll see GPAIMs on one side and AI systems on the other, and GPAI systems in the middle. What's that designed to do is to demonstrate that some of the law is pointed at general purpose AI models, that's GPAIMs, and those are the likes of GPT-4, GPT-5, Claude, Gemini. So these are significant models of parties that will be regulated by this piece of the law, which has absolutely nothing to do with any of us on this webinar. On the right-hand side is where things get more interesting for us operating in these spaces, both as those who produce the technology and those who use the technology. Both of us are covered. And they are represented, or let's say the regulation of these uses of AI, represented by this pyramid that the Commission produced to try to explain the law. And the pyramid is to be read from two perspectives. One, it's got 4 layers, and 2, it's got volume in each of the layers. At the very top of the layer, you've got what's known as unacceptable or banned uses of AI, and they're things like credit scoring or the kind of Minority Report example of, crime prediction. Again, I really don't think it's for the discussion on this webinar. The next one down is high-risk AI systems, and these are highly regulated uses of the technology, and we will touch on that in the next couple of slides. Beneath that is limited risk AI systems, and these are things like chatbots or other systems that interact with humans. And at the bottom of the pyramid, you have low-risk AI systems, which are essentially unregulated. I spoke about volume of each of these layers, and the point being made by the use of the pyramid is, if you're at the top of the pyramid, it's the smallest amount of volume, which equals the smallest amount of anticipated uses in the EU market. Therefore, once you get down to the bottom of the pyramid, the largest volume, which is the unregulated use of AI, well, under the AI Act at least, maybe not GDPR, the message being delivered by the Commission is we're targeting at very certain small number of uses. The vast majority will be untouched by this legislation. Of course, will that actually play out? In fact, we don't know. We'll see in due course. The interface between the systems and the models is general purpose AI systems. From your perspective, you think of these as ChatGPT. So it's the user interface that sits in front of the model GPT-4, or the Claude that sits in front of Sonnet, etc. So again, I don't think that's much of an interest for this particular audience. We're going to focus in on the right-hand side, and we're going to focus even in on only a couple of those aspects, which I think might be of use to us. So if we could move on to the next slide, please. So the 4 categories of AI systems are set out here. And as I'd said in the last slide, you have to think about it in the context of where possibly could you land in order to understand, does this law actually mean much to me in any event? And the 2 big questions you have to ask yourself at the outset is, am I actually a creator or what's known as a provider of one of these AI systems, or am I in fact a user or what's known as a deployer of the AI systems? So here in Mason, Hayes and Curran, we do not create any AI technology, but we do use it. And I'll speak a little bit about that later. So when we look at this risk pyramid, we think about it from the concept of, well, I'm not on the hook for the big picture stuff because I don't provide the technology, but I am on the hook for what I use. And then you narrow down your focus under the legislation to see, well, what actually do I have to kind of swallow under this piece of law? The same applies to everyone on this webinar. Now, that may be that some of you are only users, but some of you may be providers. And in that case, we might move on to the next slide and start talking about some of these in a little bit more detail. As I said, I'm not going to speak about prohibited AI because I think it is kind of a way out there sort of thing that's probably not going to affect any of us here. I am going to speak about high-risk AI systems. And the first thing to note about high-risk AI systems is it is an exhaustive list. So it's an exhaustive list of uses of AI technology. And there are two lists. One of them is in Annex 1. What I have here on the slide here is the other list, which is in Annex 3. The list in Annex 1 is very much focused on physical products like toys, machinery, lifts, medical devices, in vitro medical devices. There's one specific software example in the software as a medical device in there, and there are others, but broadly speaking, the way I distinguish the two lists is Annex 1 is about physical products, Annex 3 are the software uses where we were going to have have a little investigation here. There are 8 headings, and if the use of your technology falls under one of these headings, it is going to be classed, or more than likely classed, as a high-risk AI system and will need to be compliant with quite a strenuous regime by the 2nd of August 2026. The first list is all about the use of biometrics for identification or categorization or emotional recognition. The second is critical infrastructure, which covers things like, use of AI as a safety component in the grid, or in anything to do with water or roads or traffic. The third is education. What's kind of involved here is things like, the grade scoring that was used in the leaving certificate during COVID. The fourth is employment and is by far the one we get asked the most about, and we have the most amount of our clients operating this space. And this is uses in the recruitment of candidates and also in the use of the technology once people are in your organization. So this is a use for, let's say, compiling a whole bunch of resumes or CVs, giving the AI system a job spec and saying, choose me the best employee. That's going to be a high-risk AI system. Equally, if you're monitoring your staff using AI, giving the AI a whole bunch of metrics and telling you, how this employee is doing and what are suggestions for the employee, that's high risk also. We're going to come back to essential services on the next slide because it merits deeper thought for this particular group. Law enforcement, migration and border control, and administration of justice. And actually in the administration of justice paragraph tucked in there, paragraph 8b is also a classification of systems that are used in the context of voting and referendums and elections is in there also. So that's a highly topical one at the moment, as you can imagine. So moving on to the next slide, we have category 5 from the last slide, which is essential private and public services and benefits. And I've plucked 2 of the bullet points from that category because I think they're highly relevant to this audience. So the first one is category B. These are AI systems intended to be used to evaluate the creditworthiness of natural persons or establish their credit score, with the exception of AI used essentially for fraud. And the second one is AI systems intended to be used for risk assessment and pricing in relation to natural persons in the cases of life and health insurance. So I am sure there are a few of you on this webinar who are looking at that and going, I either might use technology like that, or I might know someone who's producing technology like that, or I am producing technology like that. Also, you're probably aware that a lot of these areas are highly regulated already before the AI Act. And so there's probably elements of thinking about these in the context of those laws where things might be already very tightly run. Broadly speaking, though, what is this all about? If your AI system is doing category B or C, or you are using an AI system doing category B or category C, it is probably going to be a high risk AI system. It will have to be compliant by the 2nd of August next year, which is an incredibly tight deadline at this point in time. The reason it's tight is that the comparison of what the compliance uplift looks like would be like the crude analogy I always use would be something like a medical device. There's an amount of documentation and SOP that needs to be hardwired into the product engineering and the processes for bringing the product to market. And they all have to be in place, and a declaration has to be signed, and it has to be registered with the new EU high-risk AI system register all before the product is launched. And then once it is launched, it's subject to a post-market monitoring regime where you as the provider are compelled to make sure that the product is conforming and complying with the processes and procedures you put in place. And so you can see it's an incredible undertaking to actually get one of these products market ready. And there are also obligations for those who use it, which is a good place actually to move on to the next slide, where we're going to talk a little bit about the most common use. So moving away, let's say, from the very sector-specific insurance type uses, which is one absolutely for all of you to have on your radars and start thinking about. The one, as I said, that I come across most often is HR uses. And I want to talk about this from two particular perspectives. The first one is the most obvious one is here in MHC and in all of your organizations. I honestly cannot see a world where we will not be using this technology over the next 2 to 3 years. And after that, it will be embedded in everything we do. This means that under Article 26, we will be deployers of a high-risk AI system, and all of us, including ourselves here, will have to put certain certain processes in place in order to comply with Article 26. So to kind of reiterate that point, users of this type of technology will have hardwired obligations under the AI Act. So you have to use the technology in accordance with the provider's instructions. You got to have someone in the organization who has knowledge to be able to oversee the AI system, and they have to monitor the operation of the AI system to flag things like serious risks to the provider or to a market surveillance authority. They also have to ensure that input data is relevant and sufficiently representative in view of the intended purpose of the high-risk AI system. Kind of, how would I quantify this new obligation? I think it's more than material. It's more than minimum. It's just shy, I'd say, of material in that, you have to do something and certain processes and procedures need to be in place in order to use the technology, but it falls very way down the list, I suppose, of what the actual provider or the creator of the technology has to do. They're looking at hiring new people, creating teams, regulatory teams, and investing, 6-figure budgets in order to get these products to market. Those of us who are users would just have to essentially follow the instructions and a few other things. I'm not saying it's negligible, but there is work to be done. One more point before I move off this particular slide. It relates to organizations who have really good engineers in the organizations, and those engineers getting really playful and being really good with using the technology internally. Beware that the regulation of high-risk AI under the AI Act covers internal uses as well as commercial product uses. So, for instance, as happened to a couple of our clients, if you suddenly decide that you or your engineers suddenly decide they can create an internal app based on one of the ChatGPT models that is able to churn resumes and CVs to give you the sort of candidate recommendations that you're looking for, you are creating a high-risk AI system, and you will be the provider of a high-risk AI system to your own organization with all of those incredibly challenging obligations under the AI Act. And individuals, if they like, can make complaints to the Market Surveillance Authority under the AI Act. So you can see a world where employees would do so if they felt, or even candidates would do so if they felt aggrieved. So that's more of a warning to stay within your swim lane when it comes to your obligations. And like everybody else is speak doing internally ourselves, the best thing to do when you're looking at AI technology in HR is to buy it in. Don't get clever internally. If you could move on to the next slide, please. Very quickly on the penalties. The penalties are incredibly high and they're there to encourage everybody to comply. They're higher than GDPR, they're higher than the DSA. So main point is, beware. Can move on to the next slide, please. Okay, so that's the end of the AI Act piece, kind of the hard law piece. And your watch outs are don't get clever with internal uses, beware about insurance scoring, credit scoring, and life and health scoring uses, whether you're going to be a user or whether you're going to be a provider. And we'll come on to one final piece towards the end about the AI Act, which ties it all together. Moving now on to the second piece, which is the AI governance, which is, in my opinion, a far more tricky beast to tackle. When it comes to the AI Act, you can look over the last couple of slides that we've done and try to identify, where you might fit into the puzzle. The AI governance piece is a lot trickier because it brings in different laws like GDPR, security, safety, and then these kind of incredibly hard to pin down concepts like AI ethics and responsible AI or safe AI. The market messaging, and when I speak about the market messaging and thinking about things like LinkedIn and what consultants might be selling, is incredibly challenging because you might be sold an AI governance or AI compliance product that is incredibly challenging to try to implement from, let's say, an ethics perspective. And the real challenge with trying to set your mind as to what's a reasonable, pragmatic, kind of safe thing to do is to try to understand what genuinely is your risk exposure. And that really, really depends on the sort of technology you're using. And the scenario you really want to avoid is building a gold standard AI safety ethical position, which is not justified for maybe a very, very bog standard use of the technology. So we're going to address some of these points over the next few slides. If we could move on to the next one, please. For most of us, at a very practical level, the trigger for having these conversations about AI governance is the introduction of generative AI to the market a couple of years ago. And when I say generative AI, I mean you ask a bot a question and they give you an answer back. But they're not giving you an answer, let's say, in most cases anyway, based on having a limited amount of information and giving you back a very limited amount of information. You are able to ask incredibly broad questions and get really, really good detailed answers. So this brings about challenges. There are many different types of the technology on the market at this stage. Is really exploding in the market. One of the most common products people will be aware of is the Microsoft Copilot product, which in most cases will be embedded in your own instance of Office. ChatGPT is by far the most popular kind of app out there on the market, and it can be used in a variety of different ways. Claude is a significant competitor to the ChatGPT product and is made by Anthropic. There are also other issues which relate to things like the Microsoft Teams or Zoom or other products which have the capacity to record transcripts of meetings, record the meetings, and give you bullet point summaries. And people are very nervous about that, and that comes with its own issues also. So if we could move on to the next slide, we start looking at some of these issues. At a very, very high level, the following are kind of four of the most well-known issues with the technology. And they are as follows. Because you are dealing with, let's say, a free chatbot, any of them, pick any of them, Gemini, Claude, ChatGPT. When you ask it a question, you are providing information to a bot that is churning an answer for you, but you have to ask yourself the question, where is the information I'm giving the bot going? And in many cases, you probably won't know the answer. So putting your legal hat on, you're essentially breaching confidentiality if you are to hand over information to a bot. And, later on, Laura's going to give you some examples of some case law where people are using the technology and looking quite foolish in front of courts. But another thing you need to think about is, what if I'm disclosing information to a free chatbot? Am I breaching confidentiality? It then follows that if the information you're giving the bot has personal data, are you breaching privacy laws? And then it follows from the confidentiality piece. Well, if I'm breaching confidentiality, am I destroying privilege in the context of an action? And the straightforward answer is absolutely yes, you are, because you are providing information to essentially a public database where you've no control over what's happening. A related point is about trade secrets and intellectual property. If, for instance, you are an engineer or there's an engineer in your organization, or they are looking at data points in a particular insurance space and they're using a free model to do a whole bunch of churning of questions and answers for them, and this is very, very sensitive internal commercial information, well, you've automatically breached the confidentiality that might underpin those trade secrets and undermined the fact that they could be protected. And the same goes for intellectual property, particularly in the area of patents. So they're the kind of the core legal issues, but then you also have the kind of very practical issues, which is the reliability of the outcomes and the potential for hallucinations. And I'm going to leave Laura to show you the kind of the outcomes from a legal perspective, but it's just to know that the systems are programmed to give an answer. So they will give an answer. And sometimes when they can't find the answer you're looking for, they will make up an answer. Now, the degree to which these hallucinations happen, I understand anyway, is lessening all the time as the bots and the companies who produce this technology are becoming more and more sophisticated. But do know that essentially you're dealing with what I like to kind of compare to, that person you might meet in a pub, and they always will have an opinion on something, and they will always be able to give you an answer regardless of whether their answer has any truth or basis to it at all. Essentially, you're dealing with a very, very smart version of that. And think about that from the concept of the risk that relates to the outputs. So should I rely on the outputs? In many cases, you absolutely can. It's just being able to identify it. The final risk then is over-reliance. There comes a point maybe when you might get really good at using the technology, and you personally, the best use of the technology is when you kind of know the answer anyway, and you're just looking for the detail, or you're trying to get to the answer very quickly. So when you know the answer and the answer appears at first blush to be correct, you might tend to over-rely on the answer. So again, the warning would be ensure that you are getting into the detail and you are reviewing the detail and making sure you're not falling into any traps. If we move on to the next slide, please. There is a nuance to the use of the technology, which I think deserves one slide. And this is the difference between using free Gen AI and enterprise Gen AI, private Gen AI, and bespoke Gen AI. I'm going to explain each of them. Free Gen AI is where I open up my laptop. I've never used ChatGPT before. I put it up on the website and I start using it. That's free Gen AI. I have zero control over what's happening when I put information into that. Also, the information might be used to train the model to be better collectively the next time it's being used or the next model's being created. Go back to the previous slide and you have all of that information then about, breaching confidentiality, privilege, disclosure, all that sort of thing. When you use free Gen AI, you have to be very careful about how you use it. I'm not saying it's not useful. I use it every day, but I use it in a very guarded manner. Enterprise level Gen AI, people often ask me this. They say, well, I have an enterprise model of Gen AI, so I'm fine. Like, I don't have to worry about all those kind of confidentiality and privilege pieces. And my answer is, yeah, well, tell me about where the data is going. Is the model training on it? Is it secure? How do you know all these things? In most cases, if you go and get like a corporate license to, let's say, ChatGPT or Claude or something else, you've essentially got like a better deal is what you've got on your licensing, and you might get a few more bells and whistles, and maybe the training on your data piece has been turned off. But none of the problems with regard to disclosure and using the technology have gone away. So when I look at free Gen AI and enterprise Gen AI, I don't see a massive amount of difference when it comes to legal risk, unless you have certain assurances with regard to how the data will be used. Moving then on to, let's say, private Gen AI or kind of a locked box type Gen AI. This is where things start to get a little bit more interesting and more freedom comes in. So organizations, let's say, that have like their own Office 365 subscription, and have that strong branding and protection of the Microsoft label, they might get Microsoft Copilot delivered under the same conditions. And those same conditions might be, a very secure, locked, private cloud scenario where nothing is leaving the cloud. And in that case, you might start to think about using the Gen AI for more tricky tasks, including using personal data, subject to, making sure you're okay under GDPR. And a bespoke system is one of the models we're looking at internally here in MHC, where you are essentially training the models on your own data, and making sure, again, that it's in a highly managed, locked container environment, so you can use data that you wouldn't otherwise use in public models. So the key takeaway from this particular slide is think about the security, access, and controls that relate to the type of AI system you're using, and specifically Gen AI, before you make any decisions with regard to what you put into it. If in doubt, err on the side of caution. So if we move on to the next slide, we'll have a look at what those kind of possibly can go wrong. Laura's going to talk to you about what has gone wrong in the context of litigation. Here's another one to throw out to you. It's not, I suppose, massively relevant from the perspective of a lot of you when it comes to, oh, this could happen to me, because it's a freedom of information case. It was published by journalists in The Guardian, where they managed to catch Peter Kyle, who was the secretary in charge of things like AI in the UK previously. They found out from doing an FOI request on his chats with ChatGPT that he was asking ChatGPT about, policy issues with regard to how to use, Gen AI across his own department. Now, that's just kind of embarrassing for him. It's not kind of any kind of incredible legal issue, unless he was actually putting anything, very sensitive in there. Why am I making the point? The point I'm making is that often people sit on their own one-to-one with their computer and they go, oh, listen, who's going to find out if I'm using this for this just one little case, this one little thing. The fact of the matter is that journalists have used it in FOI to be able to reach in and actually get the prompts or the questions he asked in using the tool. So think about that in the context of an action or discovery. So it's already been shown it's possible to get them. So it will be possible to get them again. So the main point being is that you need to think about how you're going to use this technology and use it safely. And essentially, you're going to need to get in place policies, but we'll come on to that. If we can go on to the next slide, please. When it comes to free models, and this is what I mean, you haven't paid anything for your ChatGPT, you're just using it on the internet, and even the enterprise ones, as I've kind of pointed out. Put no customer or sensitive commercial information in at all. It's just a plain hard rule. I mean, we issued our own AI guardrails internally in MHC in 2023. There was not a big policy. It was just a few bullet points to try to be incredibly direct and straightforward with people, to say, listen, do not do this, 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 and this, because you will get into trouble and you'll get the firm into trouble. And we do education on that and enforce those guardrails. What is it good for, though? Like, I'd want it to be, quite negative, because I say I love the tech and I use it all the time. I think it's brilliant for brainstorming, playing devil's advocate, creating first drafts. You might think, oh God, if you're creating drafts, are you not putting customer or client data in? I'm not. Let's say, for instance, I'm looking at a contract for one of our AI clients, and I just need something quick on, quite a knotty or detailed consequential loss piece in a liability provision. Well, I can just go and prompt the engine to give me something that I'm asking for without putting any, copying and pasting any text in. And you would be surprised if you are very, very detailed and specific about how you instruct the engine, you can get some very, very good information out and very quickly, which then you take out of the engine, you tailor to fit back into the contract you're looking for, and you can move on. Another tip I would give you is that the best way to use the tech is to use it, the app on your phone, because of great dictation. And when you're logged into the app on your phone and your desktop, whatever appears in your app will automatically appear in your desktop. So you can literally speak to the app and ask questions and follow-up questions very, very quickly. When it comes to the outputs, you always have to check them. And I would still maintain that the best use is always to those who know how to use the machines properly and well and efficiently, but also when you kind of know the answer you're going to get, so that you're able to ensure that you take away that element of surprise, I guess, that, if you know what you're looking for and you're just trying to get it faster, you're trying to get some new information that you will then check, it's incredibly useful. If you're in a complete dark space of research, kind of beware. It's still very useful, but beware of outputs. And then the final piece is that it never ever should replace your professional judgment. And this is this kind of over-reliance piece I made a couple of slides ago, which is it's all fine and well to think the answer is grand, but you really do need to take what it's given to you as nothing other than building blocks for building your own advice or your own suggestions, and taking them into account rather than it being your output. So if we can move on to the next slide, please. This is the bit for all of us, and this is the bit that kind of ties it all together from a how do I approach the AI piece. All of us, every single one of us who uses AI in our organizations, be it the smallest amount of use of Gen AI or Microsoft Copilot, are compelled under Article 4 of the AI Act to put in place AI literacy training. And this, believe it or not, the deadline was the 2nd of February earlier on this year. We did our training in January across the firm. Most people have missed it. You will start to see a lot of consultants start pushing a product around AI literacy. What is it? There's a lot to it, but at a very, very high level. It's trying to understand the sort of AI you use in your company, your firm, or whatever it is, categorizing the risk associated with it, training your employees on that risk, but also on the benefits of the technology. So it's like, here's how to use it and beware of doing this. Essentially what I've been doing on this session here. But there's also some nuance to it in that, you wouldn't give the same sort of baby steps training to the engineers in your organization who might have a lot more information, and maybe they need something more detailed about how to use it, a little bit more detail around cyber or other things. So it's a kind of a horses for courses piece. It cannot be enforced before the 2nd of August 2026. But our advice would be to get on board with it as soon as possible, because regulators will start checking in due course. Which brings us on to the next slide, please. From my perspective, if you were looking at this as, what should I do next? I would take the AI literacy training as your linchpin internally. It has to be done. It's a hard legal obligation, so it's something that can easily be sold internally. And it sets off a kind of a chain reaction of how do you approach the AI governance, good AI governance in your organization. And you look at the training piece, you can look at what we're using, and then the follow on from that will inevitably be new policies and procedures. And so then I finish up with the final slide here, which is the action points for everybody to take away. So the first thing would be create an inventory of the AI systems you're using, and also at the same time, are you a provider or a deployer? An incredibly important distinction, because your risk use case goes up and down. Got to comply with the AI literacy piece. You got to use an appropriate, probably AI policy at a very minimum to using the tech. Then for this particular audience, also have a look at the European Insurance and Occupational Pensions Authority opinion on AI governance. It's a kind of a risk-based assessment to using AI in the business and products based on existing laws like Solvency II and DORA. So it's not really focused on the prohibited and high-risk AI side of things. It's more pointed at people who are using the tech, and how to think about a good AI governance process. And at that point, I think it's good to hand over to Laura, who's going to take you through some specific examples around the use of the tech.
Thanks, Brian. Hi, everyone. And as Laura has said at the introduction and Brian has referred to, I'm going to be looking today at the uses and misuses of Gen AI. So we might just move on to the next slide there. That we are seeing in litigation matters, as well as how we are seeing the use cases for Gen AI developing in discovery and DSAR reviews. I suppose looking first at the use and misuses of Gen AI, I'm going to talk a bit about the case law. And I suppose when the first case that we're going to look at came to prominence, highlighting the issues regarding the use of Gen AI, it was quite startling and a bit kind of shocking to most lawyers that this could actually happen. But as time has gone on in the last 2 years, we are seeing more and more instances of this happening. So we might just move on to the next slide, please. And we'll jump forward again. Sorry, we're a little bit behind on the slides there. Yeah, perfect. So in the case of Mata, the Mata case, which was a US federal court case, lawyers for one of the parties were sanctioned for the use of ChatGPT in preparing their legal submissions. The two lawyers prepared legal submissions on behalf of their client, and they used ChatGPT to find case law that supported their arguments. So they failed to properly check the citations, and it ended up that they actually included case law which simply didn't exist. Their opposite numbers, not surprisingly, raised the point that they were unable to find the cases, and the court requested the lawyers for the plaintiff to file an affidavit with the cases exhibited. The lawyers, kind of making matters worse for themselves and their client, went ahead and filed an affidavit with excerpts from the cases exhibited. The presiding judge examined the affidavit and noted that the cases were bogus and the citations included were also bogus. The lawyers then admitted to the use of ChatGPT, and one of the lawyers went on to file a further affidavit claiming that he had misunderstood the ChatGPT and what it was, and he thought it was a sophisticated search engine, claiming that if he properly understood it, he wouldn't have used it. The lawyers were fined, but I suppose the most important takeaway was that the judge noted that there isn't anything inherently improper about using a reliable AI tool for assistance, but that the existing rules imposing a gatekeeping role for lawyers to ensure the accuracy of their findings remains in place. This trend, I suppose, has continued since 2003, as I said, and there's been a sharp rise in the number of use cases where we have seen the way in which Gen AI has been used and that has been criticised by the courts. So we might just move on to the next slide there, please. And closer to home, in a recent Workplace Relations Commission case involving Ryanair, this issue arose again. And this was a case involving, as I said, Ryanair were the defendants in the case, and the claimant brought a claim for €170,000 in compensation for dismissal, harassment, and constructive dismissal. The claimant, Mr. Oliveira, was representing himself in the proceedings, and Ryanair's lawyers indicated that the submissions prepared by the claimant may have been generated with the assistance of artificial intelligence, as some citations provided did not have the outcome stated in the submissions. In particular, I think one citation referred to a case which had come before the Equality Tribunal in 2016, and the claimant claimed in the submissions that this had resulted in an award of €15,000 being made, where in actual fact the case had been dismissed. During the hearing, Mr. Oliveira admitted he may have used AI, but he was a bit defensive on the topic. Again, the adjudicator in the case wasn't particularly concerned that AI had been used. So again, bringing through that theme from the Mata case, that the use of AI itself is not the problem. But she did note that the parties, obviously coming before the Commission, are obliged to ensure that relevant and accurate submissions are made, which don't set out to mislead. Here, the submission was rife with citations that weren't relevant, were misquoted, and some instances just didn't exist. And the complainant had wasted a lot of time before the Commission in seeking to establish the veracity of these false citations. So the adjudicator commented that the relying on these phantom citations to support the case was egregious and an abusive process, and the claim was dismissed in that regard. Another case is the Redden and the Board Planola judicial review proceedings case, and again the court questioned the terms that were referred to in the submissions and noted that they sounded like they'd come from AI. So we might just move on to the next slide, and this is the final case that I want to look at briefly today. And that's a recent UK case in the Herangi case, where again, we're seeing this theme in relation to the preparation of submissions. There was multiple non-existent citations were referred to. Now, the court didn't make a finding of fact here as to whether AI had actually been used, but in the context of an award of costs, the cost was reduced based on a number of factors, but including that the issues that had arisen in relation to the plaintiff's submissions. As I say, the court didn't make a finding of fact in relation to whether AI had actually been used or not, but the court did comment on the potential professional consequences of such conduct and noted that had the barrister used AI without verifying the information, the judge considered this to be, on the balance of probabilities, negligent. So again, it is reasonable to expect these types of cases are going to become more and more frequent as the use of Gen AI grows. And it's clear just from the few cases we've looked at there that the courts don't have an issue or an objection per se to the use of Gen AI in the preparation of cases. But, and it's a big but, there is an overriding requirement, obviously, to ensure that the results are accurate and verified. And we might just move on to the next slide there then. And this is just outlining what the Bar Council have said, and they've issued guidelines in relation to the use of AI. And I suppose these can be kind of summarized and summed up in relation to 5 points. Again, reflecting what Brian has said, prompts must be accurate. They must be correct and accurate. Everything that is generated by AI must be reviewed and checked for its accuracy. You must verify, and check that all of the legal principles and references are accurate and that they exist. And I would say you check and you double check that that's the case. And then you repeat everything again and you check again to avoid hallucinations. So I suppose looking at the principles that have emerged from the recent case law. And again, just to summarize, the use of AI as an assistance tool isn't prohibited, but it should only be used. It shouldn't be used, obviously, as a substitute for the proper exercise of professional judgment and due care. So we might just move on to the next slide to look at, I suppose, the uses that are being developed in relation to AI. And I know Brian has touched on some of these already, and obviously in relation to research, we're all using it for that initial research purpose, but with the clear proviso that information has to be checked and verified. I think probably one of the lowest risk case uses that we're seeing emerge is document summarization, where you're being you're asking the tool to summarize key points of a document. You have those key points in front of you, you have the document, so it's easy to check and to verify the output and to check that there has been no hallucination. Again, preparation of initial drafts of documents or initial clauses of drafts of documents, as Brian has alluded to. And I suppose the other way that we're seeing it develop is in relation to the review of documents in the context of both discovery and DSAR reviews. And that's what I'll kind of delve into in a bit more detail now. So we might move on to the next slide there. Please, thanks a million. So basically in relation to DSARs and discoveries, in particular in relation to discoveries, there's an early form of AI is in use already in review platforms, and that's continuous active learning, or CAL as it's known. And that's widely accepted in practice in Ireland. And it would be really unusual in a large scale discovery review today not to deploy CAL. However, with Gen AI, the use of CAL is accepted and it's a widely accepted practice, but the way in which it's deployed and the interpretation of the results can be open to dispute between the parties. So just to give a kind of a very broad overview, like CAL works in that it predicts the relevance of documents based on the ongoing review. So as people are reviewing documents, it will promote the documents it sees as most likely to be relevant to the top of the review queue. And as the review progresses and decisions are made by the review team, the relevance ranking of the remaining unreviewed documents is updated. So that's the continuous part of it. And then when the relevance rate of the remaining unreviewed documents gets to below a certain point, usually in around the 40 to 50 mark, a decision is made to cut off the review and rely upon the analysis of the model, the CAL model, that the remaining documents are extremely and statistically extremely unlikely to be relevant. So this ensures, I suppose, that all the documents in the review set don't have to be manually reviewed, and there's a statistical analysis to support the point at which you stop the review. So I suppose, as I said, CAL is used widely in discovery reviews at the moment, and the next step then is the adoption of the Gen AI technology in the conduct of reviews. So review platforms have been developing their Gen AI technology over the last number of years, and it is coming to the fore in consideration as to how we approach large-scale document reviews. We're not yet at a point, and I think we're some time away from it, where an entire population of documents in a large discovery or DSAR is going to be inputted into a Gen AI model, decisions made by the model as to the relevance and privilege, and the output is relied upon and sent across to the other side. What we are seeing is that use cases will be developed for certain subsets of documents for analysis based on certain prompts. For example, at the end of a review, of a very large discovery, you may use the Gen AI functionality to analyze the document set and to get a better handle on what's actually in the documents that you're disclosing. Because when you get to the end of a very large review exercise, there's a considerable volume of documents. You may have had a large review team looking at all of these documents over the past weeks and months, and it can often be a bit difficult to get a proper overall sense of what's in the document set or what is relevant to certain pertinent issues. And that can be addressed through the use of Gen AI. So you're putting a subset of the documents through the model to get a better sense of the overall view of it. And then I suppose in relation to DSAR reviews, CAL has had limited use in relation to DSARs, data subject access requests, because the ability to determine the relevance of documents in a DSAR is quite difficult, where personal data can span such a wide range of issues. It could be from performance to pension entitlements to somebody literally having a chat with their colleague about their holidays last week. So therefore, it's very hard to train the model to identify what is relevant in the context of a DSAR. So I think there's a couple of areas where we'll see Gen AI assisting in relation to DSARs. One is the identification of routine business data. So anything that is routine business data is usually excluded from scope in a data subject access request. And it's very hard just through searches and through the kind of the general filtering tools in a review platform to identify that routine business data and not to have to manually review it. So through, I think, the accurate use of prompts and providing descriptions of what an individual's role is, who they report to, sorry, the lights have gone off, it will help to identify that routine business data and exclude it from the document review set. It will be obviously important, as we have said repeatedly, that information can be checked and verified, and that there's a validation process used in relation to the documents which have been excluded through the use of Gen AI and the prompts. I think the second use in relation to DSAR is, anyone who deals with DSARs on a regular basis is very used to the headaches which are caused by the need to redact third-party data from documents, particularly large spreadsheets, etc., before it's provided to the data subject. And there are tools which are available within the review platforms which assist with the automated redactions. And Gen AI, I think, will add to the functionality of these. So we might just move to the next slide there, if that's okay. So I suppose just looking at the clear benefits and risks, and these are kind of over the next two slides, to the use of Gen AI in the context of document review exercises. And there are risks and benefits as there are for all the uses of the AI technology. And again, I've just set these out on the slides. But one, I think, which is really important to note, is that there are cost implications for the use of this technology. It's not, within these review platforms, it's not as simple as just, pressing the button and it's all included. The way in which the cost structure is often set up is that it is dependent on the volume of documents for which you were putting through the Gen AI model and the number of prompts that you are applying to the data set. So therefore, the accuracy of the prompts becomes a huge factor, because the less prompts used, the less costly it is, but also the ability to verify the output. But there are cost implications of doing this. So, the benefit of using the model, reducing the number of manual hours that are required to review documents, needs to be weighed up against the cost of actually using the technology. And then I think also it's important, the verification process has to be clear. It has to be very, very clear what verification steps are being taken to ensure that the output is correct, and can be stood over. And I think, Gen AI will and already is changing how we approach the review of large data sets in discoveries and DSARs. But as in the same way that we've seen it being used for legal submissions and things like that, in all the use cases that are developing, the accuracy of the output must be verified and must be able to be relied upon. And then there's the cost benefit analysis as well that must be considered. So that kind of brings me to the end of that section. So Laura, I might hand back to you to do a bit of a wrap up and see if we have any questions that have come in that we might want to chat through.
Thanks, Laura. Yeah, I have a couple of questions here and we have a few minutes. So first one, should there be obligations to disclose use of AI by solicitors or barristers when providing advices to clients? Don't know, do you want to take that, Brian, or?
Sure, yeah, I can jump in. I think it's really down to clients and what they want to do, and it's also down to the Law Society, the Bar Council, etc., to kind of issue guidance on these specific matters. It really, really though, excuse me, depends on the technology and what you're using it for, and whether and the extent to which the actual use of the technology results in the work product, if you know what I mean. I mean, it's entirely possible to use Gen AI in doing a little bit of brainstorming, or in some prep work for a particular project, but none of that actually makes its way into the work product for the client. So then there's a kind of a consideration as to what you should do in that scenario. What you'll see in practice is a lot of clients sending in new terms and conditions to law firms to say, if you're using, AI or specifically Gen AI, we expect you to act in a certain manner and certain levels of transparency. But as things stand right now, what we're seeing is that's coming in like dribs and drabs. It's the exception rather than the norm. And it's an incredibly kind of, the area is in flux and things are moving, but they're moving for different clients at different paces. So, with regard to the market itself, there seems to be little or no kind of harmony or a particular line.
Yeah, I think I
suppose
agree with that, Brian. Sorry, Laura. I think it's very much, if you're doing that initial draft or that, initial document summarization, is very different to, the end product that is coming out just because it's being generated by AI.
Yeah, and I was just going to say, I suppose it goes back to the human oversight piece and double checking all citations. It's similar to doing research, and if it's used correctly, then there shouldn't be an issue with it.
Absolutely, sure. Like at the end of the day, it's all of our work product, right? And at the end of the day, whether there was AI or no AI, we would all be obliged to ensure that you can stand over your work product anyway, so that there's an element of, your professional judgment always has to come into this.
I think we can do one more quick question. Is there a way to ensure that third-party analytics or AI suppliers comply with the AI Act obligations, and that we as a company retain enough oversight or control?
That
probably goes back to the agreement with the suppliers, if you're engaging with a supplier.
It is, and it's a really astute question, in fairness, because it goes to the core of one of the aspects of high risk AI under the AI Act, because as a deployer, you're really relying on the provider or the organization giving you the technology to have done their job. And what you'll see emerging in the market is some players in the high risk space will make a call. They say, listen, I know it looks like I might be high risk, but I've done my analysis and I am comfortable that I'm not high risk. So in those scenarios, you can see things being a little bit trickier as to how a user will use a technology if they're nervous. I mean, ultimately, you just have to walk away from using it if you think this provider has got their analysis wrong. So there's an element of jeopardy there, you know, and you're right, Laura, at the end of the day, it all comes down to your terms and conditions and your contract and how are you managing that relationship. Ultimately, if the provider's got it wrong, it's on them. But you don't really want to be caught up in that chain of a mess either, to be honest.
Unfortunately, we're out of time. We had a few more questions, but we are at the hour now. So thank you so much for joining our webinar today. I hope you all found it as interesting as I did. At the end of the webinar, you will receive a link. So just click on the link to fill in the survey and you will then get your CPD certificate. Please feel free to reach out to myself, Brian, or Laura if we didn't reach your question and you want to discuss the topic further. Enjoy the rest of your day. Thank you.
Thanks, everybody.